I'm here this evening to ask the board to disclose the fully loaded costs of the Bennett fiasco. Others have asked for this information to be disclosed, which to date it has not. We know that the Bennett settlement alone cost $300,000. Based on right-to-knows filed, some of the ancillary costs, including court reporting, transcripts, and security fees, amount to slightly more than $9,800. Other expenses have not been quantified, such as the costs associated with the backfilling of the slot of Miss Seeley, who was moved into the interim principal role at Indian Lane. Additionally, there are opportunity costs, some of which may be able to be quantified. However, there is one expense that can be readily quantified and which has not been fully and clearly disclosed: legal fees. Based on district information that's been posted prior to this meeting, $285,000 has been transferred from two accounts to an account entitled Board Services Lawsuit Settlement. Does this represent the legal costs associated with the Bennett fiasco, or does it also include other legal costs? Does this represent both the Levin Group's and Solicitor Kelly's fees? According to right-to-knows filed by Mr. Tony D'Amato and Mr. William Evans, both of Middletown Township, the Levin Group's fees for the period November 2014 through June 2015 amount to about $33,000. In order to make the legal costs completely transparent and understandable to the taxpayers, I am requesting, as others have, that the district post Mr. Kelly's fees and the Levin Group's fees as separate line items with detailed descriptions so that taxpayers can get a handle on legal expenses. I would like to address Mr. Kelly's fees. William Evans filed a right-to-know request for the solicitor's fees related to the Bennett Circus. Grace Eves, Director of Management Services, provided 494 pages of Mr. Kelly's timesheets and invoices, but none for the time period of the Bennett matter, and all descriptions of services provided were removed, so Mr. Evans' questions remained unanswered. When he requested specifics, Mr. Evans was told the information could not be disclosed because it fell under the attorney-client privilege exception. Has the board forgotten who the client is? The client is the taxpayers, whose money has been used to fund the Bennett legal excursion. The board and Ms. Eves need to stop hiding behind attorney-client privilege. It's beyond time to come clean. The taxpayers have every right to know. Not providing the taxpayers with fully disclosed fees associated with the Bennett matter demonstrates the board's and the district personnel's utter contempt for the taxpayers. And should full disclosure of all costs associated with the Bennett fiasco not be made, the taxpayers have every right to make this a campaign issue for the three incumbents, Ms. Schneider, Ms. Nolan, and Mr. O'Donnell. I'm asking everyone in the audience to hold the board to its promise of transparency and to penalize the three incumbents by voting them out if they do not honor this promise. Thank you.